Imagine a law that gives the U.S. president the power to order military action in a foreign city to free Americans. Sounds like a movie plot, right?
Yeah, but it's very real. And it's right at the center of what's happening now.
Okay, so what's the latest?
Well, just recently, the U.S. government slapped sanctions on 4 international criminal court officials. We're talking judges, prosecutors.
Sanctions. What does that mean exactly?
It means freezing any assets they might have in U.S. jurisdictions. And this is aimed squarely at officials involved in trying to investigate or prosecute American or Israeli nationals without, getting consent from either country first.
Right, and this isn't the first time we've seen this kind of friction, is it?
Not at all. You might remember the Trump administration did something similar. They threatened and then actually imposed sanctions on ICC personnel who were looking into U.S. military actions back in Afghanistan.
The Afghanistan investigation, that involved U.S. personnel.
It did. Both U.S. military and intelligence folks, plus anti-government forces, too. So this latest move, it really just follows a long pattern. It's part of this consistent U.S. policy to, protect its own service members and assert its sovereignty over international courts it hasn't agreed to join.
And these aren't just abstract policy debates. They have real impacts, sometimes very personal ones.
Absolutely. Look at the recent alleged assassination plot against former National Security Advisor John Bolton, reportedly by an Iranian national, maybe retaliation for a U.S. drone strike.
That's serious stuff.
It really is. And it even affected things like his Secret Service protection. President Biden granted it, but then President Trump rescinded it in January 2025. It just shows how high the stakes are, personally and geopolitically.
Definitely. So that brings us to today's deep dive. We're going to get into this law, often called the Hague Invasion Act. The official name is the American Service Members Protection Act, ASPA.
Right. And the ongoing tensions, really, between the U.S. asserting its national sovereignty and these international legal bodies like the ICC.
Exactly. So our mission here is to unpack what this law actually does, why it was created in the first place, and how it's still shaping U.S. foreign policy today, especially with all this recent news. We'll be using legislative records, policy analysis, global reactions, trying to get the whole picture for you.
Sounds good.
Okay, let's start with segment 1. Understanding the American Service Members Protection Act, ASPA. So what is this law, fundamentally?
Well, ASPA was signed into law back on August 2, 2002 by President George W. Bush. Its main goal, its core purpose, is pretty straightforward. Protect U.S. military personnel and other government officials, too, from criminal prosecution by any international criminal court that the United States isn't a party to.
Primarily the ICC, the International Criminal Court.
Primarily the ICC, yes.
So it's like a shield for American personnel. But that nickname, the Hague Invasion Act, that sounds pretty aggressive. Where does that come from?
Yeah. That's where it gets really interesting and frankly controversial. That nickname comes directly from a specific, very powerful provision in the Act. ASPA gives the president the authority, the power, to use all means necessary and appropriate, that's the exact phrase, to free any U.S. personnel or even personnel from allied nations if they're detained or imprisoned by the ICC or even just at the ICC's request.
All means necessary, including military force.
That's the implication. Since the ICC is based in The Hague, in the Netherlands, that clause has been widely interpreted, hence the nickname, as potentially authorizing military action in The Hague itself if U.S. or allied officials were held there. It's a pretty extraordinary claim of presidential power.
Wow. That's a very strong statement about protecting your own people. Who pushed for this law originally?
He was introduced by Senator Jesse Helms, a Republican from North Carolina, and Representative Tom DeLay, a Republican from Texas. It was actually part of a larger bill, an amendment related to funding after the 9/11 attacks.
Interesting context. And did it have broad support?
It really did. Strong bipartisan support, actually. Passed quite easily in both the House and the Senate. The key amendment, the one with the all means necessary clause, passed the Senate 75-19, including 30 Democrats. So back then, there was a wide consensus that protecting U.S. service members from this new international court was a major priority.
Which leads us right into segment 2. Let's talk about John Bolton and the consistent U.S. stance on sovereignty. Because when you mention skepticism of international bodies, his name definitely comes up.
Oh, absolutely. He's been a key figure, really a driving force behind this perspective for decades, and it builds on the fundamental U.S. position. We are not a member of the International Criminal Court. That's the starting point for everything else.
And Bolton has been very vocal about why.
Extremely vocal. He sees international organizations generally and the ICC specifically, as infringing on American sovereignty, on our independence. He's consistently argued for a strong unilateral U.S. approach.
He's had some, let's say, memorable quotes on the subject.
He certainly has. Famously, he called the decision to pull the U.S. out of the ICC process the happiest moment of his political career.
Wow.
And his views on the UN are also well known. Things like, there is no such thing as the United Nations, or suggesting that if the UN built lost 10 stories, it wouldn't make a bit of difference.
Pretty blunt.
Very blunt. His argument is that these bodies lack accountability, they undermine U.S. decision-making, and that fundamentally American courts hold Americans to the highest standards already. So the ICC is, in his views, superfluous and dangerous.
And this wasn't just talk. When he was Undersecretary of State from 2001 to 2005, he put these views into action.
He absolutely did. He was instrumental in, for example, pulling the U.S. out of talks for a verification protocol for the Biological Weapons Convention back in 2001. He argued it would put U.S. national security at risk. He gave that famous beyond the axis of evil speech, adding Cuba, Libya, and Syria to President Bush's list. And he played a key role in removing José Bustani, the head of the Organization for the Prohibition of Chemical Weapons, a move that was later condemned by a UN tribunal, by the way.
So, a very active pursuit of this policy. You also mentioned Article 98 agreements. What are those?
Right. Article 98 agreements are basically bilateral treaties the U.S. negotiated with many countries around the world.
Okay.
In these agreements, the other country promises not to surrender U.S. citizens on their territory to the ICC, even if the ICC requests it.
So another layer of protection negotiated country by country.
Exactly. It's a proactive strategy to shield Americans globally, consistent with his whole philosophy of prioritizing U.S. sovereignty and protecting citizens from what he sees as unaccountable international bodies.
This consistent stance sets the stage for Segment 3. Escalating tensions, sanctions under the Trump administration. Because these policies, they didn't stay theoretical.
No, they definitely led to direct conflict. In September 2018, the Trump administration started making explicit threats. They said they would sanction ICC personnel if they moved forward with investigating alleged U.S. war crimes in Afghanistan.
The same investigation we mentioned earlier.
The very same one, looking at U.S. military, intelligence personnel, and also anti-government groups. But the ICC's chief prosecutor at the time, Fatou Bensouda, she pressed ahead with her examination despite those threats.
And Bolton, who was National Security Advisor then, he led the charge against the ICC, right?
He did. He gave a major speech, again in September 2018, calling the ICC illegitimate, unaccountable, and, quote, a threat to American sovereignty and U.S. national security.
Strong words.
Very strong. He repeated the argument that the U.S. justice system is sufficient, that the ICC lacks checks and balances. And he made specific threats, banning ICC judges and prosecutors from entering the U.S., freezing their assets if they pursued cases against Americans or allies.
And fast forward to now, those threats have become reality.
They have. Just recently, the State Department announced sanctions against 4 specific ICC officials, Judges Kimberly Prost from Canada and Nicolas Guillou from France, and prosecutors Nazhat Shamin Khan from Fiji and Mame Mandia Niang from Senegal.
Why those specific individuals?
The stated reason was that they were, quote, directly engaged in efforts by the International Criminal Court to investigate, arrest, detain, or prosecute nationals of the United States or Israel without the consent of either nation.
So specific actions led to these sanctions.
Precisely. Judge Prost was sanctioned, apparently, for her role in authorizing that Afghanistan investigation, even though it was later dropped. And the other 3, Guillou, Khan, and Niang, were sanctioned because of their involvement with the ICC, issuing and upholding arrest warrants for Israeli Prime Minister Netanyahu and former Defense Minister Gallant over the war in Gaza.
And the U.S. justification remains unchanged.
Pretty much. Senator Marco Rubio, announcing the sanctions, said the administration would keep taking whatever actions we deem necessary to protect our troops, our sovereignty, and our allies from the ICC's illegitimate and baseless actions. The message is clear. National interest and sovereignty come first.
Okay, that takes us right into the legal arguments here. Segment 4. The legal showdown, U.S. and Israeli objections to ICC jurisdiction. This isn't just politics. There's a serious legal battle, especially over those warrants for Netanyahu and Gallant. What's the core legal disagreement?
It really comes down to the fundamental question of jurisdiction. Does the ICC even have the authority to act in these situations? One major argument from the U.S. and Israel uses this principle called derivative jurisdiction.
Derivative jurisdiction.
Yeah, there's a Latin phrase for it, nemo dat quod non habet.
Which means?
No one can give what they do not have. The argument is that the ICC's jurisdiction is derived from the state where the alleged crimes occurred. The ICC can only exercise the criminal jurisdiction that the state itself possesses.
Okay, so how does that apply here?
Well, the U.S. position is that the Palestinian Authority, the PA, never actually had criminal jurisdiction over Israeli nationals in Gaza. They point to the Oslo Accords from 1995, which they argue explicitly state that Israel kept sole criminal jurisdiction over offenses by Israelis in the territory.
So if the PA never had that power,
then it couldn't delegate that power to the ICC when it joined the court. You can't give away something you don't possess. And interestingly, the current ICC prosecutor, Karim Khan, seems to agree with the basic principle, stating the court's jurisdiction is defined by the territorial jurisdiction of its state's parties as it exists under international law.
That seems like a critical point. What happens if the ICC ignores that principle?
Well, some legal scholars, like Dapo Kande, have warned about that. He said if the ICC asserts authority beyond what states can delegate, it will just stiffen opposition to the court by non-parties. He specifically mentioned, the John Boltons of this world would use it as proof of why the court needs opposing. It could really undermine the court's legitimacy in the eyes of powerful non-members.
Beyond that specific argument, there's also a broader Israeli claim about Palestine's status.
Exactly. Israel argues, more fundamentally, that Palestine isn't actually a state under international law at all.
And if that's true,
then Gaza isn't territory within a state party to the Rome Statute, the ICC's treaty. And if that's the case, the ICC wouldn't have jurisdiction over anyone in Gaza, not Israelis, not Hamas either.
That's a huge claim. How does that affect the specific charges?
It's crucial for some charges. For example, the war crime of starvation of civilians, one of the charges against Netanyahu and Gallant, typically only applies in international armed conflicts. That means conflicts between states. So for the ICC to even proceed with that charge, it seems like they'd have to implicitly recognize Palestine as a state.
Has the ICC ruled on Palestine's statehood?
It's complicated. Back in 2021, an ICC pretrial chamber decided, by a 2-1 vote, to basically treat Palestine as a state party for the purposes of jurisdiction. They based this on the UN Secretary-General accepting Palestine's accession to the Rome Statute in 2015, and the fact that most other member states didn't object then.
But they didn't actually rule on whether Palestine is a state under general international law.
No, they specifically avoided making that determination. And it wasn't unanimous. The dissenting judge, Peter Kovacs, argued strongly that Palestine is not a state with sovereign authority over the territory in international law, and therefore the ICC lacks jurisdiction. He's actually the only ICC judge who has publicly sided with the U.S.-Israeli view on this key point.
So deep divisions even within the court on these fundamental legal questions. Let's move to segment 5, global reactions and the sovereignty debate. How did the world react to these latest U.S. sanctions?
Well, the reaction from most countries and international organizations was pretty strong, and mostly negative.
Like who?
The ICC itself, for starters. They call the sanctions a flagrant attack on its independence and an affront against the rule of law and victims worldwide.
Strong language from the court. What about the UN?
The UN spokesperson said they were very concerned and reiterated full support for the ICC as a key pillar of international justice. France called the sanctions dismaying and contrary to judicial independence.
Any other major players?
Oh, yes. There was a joint statement from 79 countries. That's about 2/3 of the ICC's members, including allies like the UK, Germany, Canada, Brazil. They condemned the sanctions, warning they increase the risk of impunity and could jeopardize sensitive information and the safety of victims and witnesses.
So broad condemnation.
Very broad. Human Rights Watch said the sanctions put the U.S. on the side of war criminals. And the Netherlands, which hosts the ICC in The Hague, firmly stated it stands by the International Criminal Court.
But not everyone condemned them.
No. Israel, which is also not an ICC member and is a close U.S. ally, welcomed the sanctions. Their position aligns closely with the U.S. on this.
It's worth remembering, too, that this isn't strictly a partisan issue in the U.S., is it?
That's a really important point. While President Trump was the first to actually impose sanctions, his predecessor, Democrat Joe Biden, had also considered using them. It shows a deeper, more consistent American concern about the ICC's potential reach over U.S. and allied citizens spanning different administrations.
And just for context, we should mention the ICC's actions aren't one-sided in the current conflict.
Right. The court also issued arrest warrants for leaders of Hamas, the Palestinian armed group, for alleged war crimes during the October 7th attack. So the ICC presents itself as pursuing accountability on all sides involved. The sources also note the tragic human cost, mentioning over 61,000 Palestinians, mostly women and children, killed in Israeli attacks in Gaza.
Okay, let's wrap up with segment 6, Bolton's enduring relevance. Looking back, his stance has been remarkably consistent.
It really has. Throughout his long career, from the Reagan and George H.W. Bush years right up to being National Security Advisor under Trump, John Bolton has championed American unilateralism and expressed deep skepticism toward international bodies. For him, it's always been about defending U.S. interest and protecting American sovereignty above all else.
And as we mentioned at the start, these aren't just abstract policy positions for him.
No, definitely not. That alleged assassination plot we talked about, the subsequent Secret Service protection granted by one president and rescinded by another, it just highlights the very real, very personal, and sometimes dangerous consequences tied to these high-stakes foreign policy stances. It's a stark reminder of what's involved.
So bringing this all together for you, our listener, we've dug into the American Service Members Protection Act, the so-called Hague Invasion Act. It really embodies this strong U.S. position: prioritize national sovereignty, protect American personnel, and push back against international courts like the ICC that the U.S. hasn't joined.
Right. And this stance, championed forcefully by figures like John Bolton and largely maintained across different administrations, has led directly to these confrontations, including the recent sanctions against ICC officials.
It leaves us with a fundamental question, one for you to think about. In our interconnected world, how does a country like the U.S. balance protecting its own citizens and its sovereignty with the global effort to seek justice for the worst crimes imaginable?
Yeah, what are the long-term consequences for international law, for human rights, when powerful nations take such a firm stand against these international judicial bodies? Finding that balance between national interest and global justice, well, that remains a huge ongoing challenge.